gaps have to highest court. Today, the Supreme Court took a plea seeking a ban on the use of metallic pellet guns for crowd control. Now, this is following allegations that they were used during the Jantar Mantar crackdown. The hearing has once again brought a long-running debate back into the national spotlight. Where should the line be drawn between maintaining law and order and protecting the fundamental rights and safety of citizens? While hearing the matter today, the Supreme Court stopped short of ordering an outright ban on pellet guns. Instead, the bench made a series of significant observations that could shape the course of the case. The court made it clear that it simply cannot prohibit the use of pellet guns so long as the existing legal framework continues to permit their deployment. If the petitioners want pellet guns to be phased out altogether, the court said, they would have to directly challenge the validity of the legal provisions that authorize their use, arguing that they violate Article 21 of the Constitution, the fundamental right to life and personal liberty. The Supreme Court didn't just hear the case today. It also took the first steps towards closely scrutinizing how pellet guns are deployed in India. What are we talking about? First is that they asked to place on record the order allowing the graded use. The second, they also asked to preserve ammunition log of the RAF or the Rapid Action Force of July 20th. Third, they've also said they will lay down protocols and guidelines. Now, officially, pellet guns are classified as non-lethal weapons, designed to disperse violent crowds without using conventional firearms. But critics have long argued that the label doesn't always match the reality on ground. While intended as a less lethal option, pellet guns can become deadly at close range. The tiny metallic pellets that they fire often leave behind hundreds of puncture wounds, small red dots across the body. But the damage can be far more severe. They've caused permanent blindness, catastrophic eye injuries, and in some cases, pellets have penetrated the skull or spine, leading to life-threatening consequences. The use of pellet guns for crowd control has been contentious for years, with every major deployment reigniting questions over necessity, proportionality, and accountability. Pellet guns were first introduced in Jammu and Kashmir in 2010 as what authorities described as a non-lethal crowd control measure, primarily during periods of civil unrest. But over the years, images of severe eye injuries, permanent blindness, have turned the weapon into one of the most debated policing tools in the country. The controversy resurfaced in Manipur in 2023, where reports emerged of at least 8 people suffering pellet injuries during the ethnic violence. Then in 2024, pellet guns once again entered the national spotlight during the farmers' protests. Protesters alleged that Haryana police used pellet guns at the Khanauri and Shambu border points. In fact, this issue was raised in Parliament just 2 days ago as well. Independent MP Abdul Rashid Sheikh reminded the House that it was the then UPA government that first introduced pellet guns in the Kashmir Valley in 2010 as a crowd control measure. Now, this isn't the first time that such allegations are coming out. Let's listen in fact to what was stated.
आज पैलेट गन की बात हो गई, मैं कहना चाहूंगा आज एंड इंडिया अलायंस से ये पैलेट गन तो आपने ही कश्मीर में शुरू किया, 2010 में 150 लोग मार दिए.
However, Engineer Rashid is not the first politician saying it, nor is it the first time that there is judicial scrutiny happening over pellet guns. In fact, the debate stretches back nearly a decade ago. The first major legal challenge came in 2016 in the aftermath of the Kashmir unrest, when the Jammu and Kashmir High Court Bar Association moved court seeking a complete ban on pellet guns, arguing that they had caused devastating injuries to civilians. The matter soon reached Supreme Court, which refused to impose an immediate ban, but made an important observation that pellet guns cannot be used indiscriminately and that their deployment must be carefully justified. The original petition then continued before the Jammu and Kashmir High Court, which in 2020 delivered its final verdict. The High Court declined to prohibit pellet guns altogether, holding that security forces could continue using them as a crowd control measure in exceptional circumstances, while stressing the need for restraint. And joining us for more on this, we have two very special guests. To approach the court, you have said, and I want to quote, you've called for the ending of the pellet gun era. But how do you respond to the Supreme Court's view that has been expressed today that pellet guns might be allowed in certain exceptional circumstances?
Did they say that? I think they said two things. One is that they said that all these standing order SOPs should be made available. That is number two. All the standing orders in this regard should be made available. Second, they said all the RAF logs should be put up. And third, that they should get free medical treatment, the victims. This is what they said, because in the first hearing, obviously, they would like to hear the state. My writ petition was banning the pellet guns per se. Pellet guns have not been used in the heartland of India. They were used in 2010 in Kashmir and 2016 with grave casualties. There were 6,222 people who were injured. The UN Human Rights Watch also came up with these findings, and there was an expert committee also which was constituted to look into the matter. And later on, again, in 2016, in fact, Mr. Rajnath Singh had ordered also acquisition of certain non-lethal equipment. The government tried. And but 2016, the MHA let out an SOP for use of the pellet guns. It was not banned. And it said that it will take 3 days training. It will be used as a second last resort. And in 2018, in Parliament, the minister said two things. One is pellet gun is not banned, and an SOP has already been prepared by the MHA, but that SOP has been kept a secret.
Okay. And let me bring in Dr. Vikram Singh on that note. Dr. Vikram Singh, why has that SOP A been kept a secret? Why is it not publicly available? Because even in terms of, the graded response, etc., has that been followed is a big question that is being asked in the context of Delhi. And where do you stand when the court has raised the question about whether a complete ban on pellet guns can be legal in the first place?
Good evening, Madhavji and Mr. Yashovardhan, my esteemed colleague. I would say that I have my own reservations about banning anything. If any SOP is not in public domain, then it is not an SOP. And SOP is something that needs to be drilled in a manner that it becomes a reflex action on the part of those who are using the pellet guns. If that does not happen, then there's no point in having an SOP. The fact of the matter is, a weapon is only as good or as bad as the person who is using it, and also the philosophy with which he is pulling the trigger. Any weapon can be put to optimum use, and any good weapon can be put to absolutely disastrous use. The fact of the matter is that there should be a judicious use of weapon. I have known people using that they did not even have to use the lathi charge. Their word was good enough. A sound lathi charge can deliver the results if that is possible. But a lathi charge misused, Mr. Yashovardhan and I are on a platform of IPS officers that said an indiscriminate use of lathi can also end up in blinding and maiming and of having disastrous consequences. So it is not just the weapon, it is the philosophy and how I intend to use it. And therefore, I would say, under the face of what happened in Delhi, Mr. Madhav, tell me that 130 police officers, police women injured, 30 vehicles touched, the policemen were being brutalized, and the manner in which they were pushed around and attacked. I think pellet gun was something that could have been used to optimum use. Again, it was a different matter that the ACP, I think Raja Bhatia, the GD entry came a little late. Then the entry also said then Mr. Bhatia, there are reports that he said that I was not at the spot. I think these things are best avoided. I mean, you have to be on the same page, number one, and there's no point in delaying, in disclosing the GD entries. And pellet gun is not something. The injury on the person whom Rahul Gandhi ji is displaying as a trophy is that it is just skin deep. It is not even muscle deep. But
there are allegations that it's pierced one of the victim's eyes. I don't know if it's that particular victim or not, but one of them is believed to have been blinded in one eye. At least that's the report that had come out.
Madhavji, if the pellet pierces the eye, rest assured, the victim will lose the eye. There is no doubt about that. We have both, Mr. Yashu and I have used the pellet guns extensively. And I can tell you that otherwise it is innocuous. But if it hits a vital part like an eye, that vital part is gone. So, but I would be very satisfied since people are making trophies of every victim. I would have been very satisfied if the injury report was stored by the LOP, but where is the injury report? If the eye is lost, where is the injury report? That cannot be concealed, and it's a very serious matter. And again, if there's a misdemeanor of again using the pellet gun at the vital part and not below the waist, is also a cause of very great concern and shows lack of trade.
And that's why I must ask Mr. Azad, these SOPs, which you, as you say, are shrouded in secrecy, even we tried to actually access some of them. But, all that we have seen is the 2011 BPRD SOP on non-lethal measures, the Delhi Police Standing Order 72 of 89, the 2022 Standing Order on rallies, where all have talked about graded force being used, but they've not mentioned pellet guns at all. In your view, how does it fail the test of constitutionality in terms of either necessity or proportionality or even reasonableness, even if it's used as a weapon of last resort or second last resort, as you were mentioning?
Very good question. Now, let me clarify this. Let us differentiate between the pellet gun ban, which I am asking for in principle and for which I have filed a writ petition, from the circumstances in which the pellet gun was used here and the clashes and the violence between the two. That is a separate case. I'm requesting a judicial inquiry to say how the pellet gun was used or whatnot. But my objection is in principle. You know why? For the simple reason that it's a technical ground, that the pellet gun use leads to an arc of fire which has an area effect, not a specific effect. Multi-projectile systems are banned in all developed countries, not only here. It is only used in Yemen, Bahrain, Iran, all those kinds of. Why have they been banned? Because the policeman has the control over the trigger, but not the target. Even when we fire below the waist. And if there is a graded SOP which is made, you have the water cannons, you have the lathi charge, you have the tear smoke, which is good enough. Electrical tear smoke were used, and the other one, the pressure ones were also used. That's absolutely fine. So given a case like this, we cannot allow, because even if you shoot somebody, you see, they were used for, hitting partridges. Koi na koi to charra lagi jayega kahin na kahin. So if you have a metallic charra going in a cloud burst, you're not able to control. You would like to hit that violent man, but it will hit the other guy on the eye or some sensitive organ. That is why, in principle, I'm against. Another thing I wanted to clear. Metallic is, of course, dangerous, but even substituting it with plastic doesn't make a difference because the effect is the same. So when you have no control over the outcome, that means the disadvantages outweigh the advantage you're gaining in terms of cloud dispersal quickly.
Yeah, what Mr. Azad is saying, Dr. Vikram Singh, can be also stated that in pellet guns, if used in crowded situations, they end up punishing proximity rather than culpability. This is something that has been stated as well. Do you agree with that objection?
I agree with it in partly, because in the sense that no weapon is 100% perfect. It has to be perfected and honed into perfection. There are checks and balances, and I would say by trial and error. By trial and error, say, Mr. Yashovardhan Azad has used the 12-bore shotguns, and I'm sure he must be aware of the Wesley Richards, the Purdy's, and the Churchills. The choking of the barrel can be set right so that the arc of fire is reduced, and it is restricted only to the spot where you aim in the general area. The range is not very much. It is something at the best about 100 yards. Doesn't go beyond 100 yards. The choke of the barrel can reduce that, and also other changes in the barrel structure will also ensure that it does not go haywire as a cloud, but it impacts a certain area in a certain time. But to throw the baby with the bathwater out, including the pellet, I have my own reservations.
Right. And Mr. Yashovardhan Azad, incidentally, this was a debate in Parliament today, and I'm asking you this only because one of the members of Parliament raised this, Engineer Rashid, and obviously it's a political question in that sense. The introduction itself in 2011, do you think the introduction itself then was fundamentally a mistake?
Absolutely. In 2010, it was used, and injuries were immense. And again, it was used in 2016. The government didn't think it proper, despite the expert committee. After 2016, there were 6,222 injuries. Now, how do you justify it? And in 9 years, there has been no difference. What Vikram Singh Ji is saying, I agree. The choking of the barrel in a particular way can sort of soften the impact because it can be directed in a particular way. But who's going to do it? Do you think our police will do it? If for 9 years they have not done any kind of a tech upgradation, do you think they will even try to do it? They have not done it, they have not answered it, and the SOP remains the same and in exactly the same fashion. And that's why I'm saying it is time. I'm saying that it is not constitutional, and in a democracy, the multi-projectile system cannot be used because it's not even used in any developed country or democracy.
And I think, apart from that, there are 2-3 other important questions, Dr. Vikram Singh, that I have. Today, as we were trying to get the BPRD details, I actually tried to visit the BPRD website. It's not working. We were told that unofficially, we were told there is some cyber threat, etc. Therefore, the website is not functional. No, the point is that if the SOPs cannot be made available on an official website such as this, why should we be having that technology? You have partially addressed that. That is question number 1. Question number 2, has the failure happened in Delhi specifically? Not talking just about the Supreme Court case where Mr. Azad has, of course, represented. Has it happened because of a lack of early action, nipping the problem in the bud when the crowd started swelling?
Madhavji, you put a question which will require me at least half an hour, but I'll be very short and brief in just 4 sentences. To your first question, if an SOP is not in public domain, it is not an SOP. Both the user and the end user and the target should be fully aware of the SOPs, and there is a warning before every use of fire, and that would include the pellet gun also. And if the warning is there, then I hope that everybody is fully aware of the SOP. Otherwise, it is courting the recipe of disaster. And to your second question, that the problem, I think we could have learned so much from the mistakes that we made in handling this agitation. We did not put our best foot forward, Madhavji, and I would say that there was no preventive arrest, there was no security for keeping the good behavior, there was no checking of the crowds who is coming in, and to say that there were 3,000 criminals. Do you think for a moment that we were just mute spectators to allow anyone and everyone to march in as if he's going to his in-laws' wedding party or something? We could have done something very proactive, and this is what we have done all our lives. Nothing changes. That we don't allow grass to grow underneath our feet. We should have been so proactive that we should have known everything even before the agitation started. But in a scale of 1 to 10, we bungled around into 3 out of 10, and that is the one reason, perhaps, I think, we changed the police commissioner, which is unprecedented, midway.
Absolutely. There are many questions about the actions that have been taken, but do you want to comment, Mr. Azad, on the graded response and how much of the protocol was followed to the T?
Yes, that's exactly. Vikram Singh Ji has absolutely hit the nail on the head. That when you are talking about graded response means that you're supposed to do preventive actions, you're supposed to do negotiations, you're supposed to build up your, response in a way that is a graduated kind of a response. Water cannons were not used. Whose command? DCP is saying he was not on the spot over there. The RAF has written the general diary after 2 days. So there are a lot of things we could have done better. It happens. I'm saying certain slips do happen, but you cannot allow, for example, women being, misbehaved with. That is not done. And in that particular case, there should be a very swift response.
Absolutely. In fact, those videos have been going viral, and of course, nobody can perhaps justify those kind of unfortunate scenes that have taken place. But Dr. Vikram Singh, I want to ask you, were the visuals coming today from Jantar Mantar, the response of the authorities has been to weld together the barricades, to create a sort of a mini fortress around that protesting area, and enforcing SOPs that only 1,000 people will be allowed. Is this a recipe for crowd control after what we've seen that has happened on the 20th?
Madhavji, you have another very experienced officer, Yashovardhan Ji, and both of us have handled crowd management. It is putting the cart before the horse and sending the wrong signals. Of course, you should prepare for the worst case scenario, but at least prepare for a good case scenario to begin with. Have some kind of a back channel diplomacy, some kind of negotiations, have some kind of use of technology like the drone technology, robotics and other things. This welding of police barriers did not serve much purpose either in the farmers' agitation or in this agitation. In a crowd of when thousands start pushing, no amount of welding and no amount of barriers would be able to withstand the pressure that is put by thousands of people. I would expect a lot better the use of technology. And also, yes, you're right, that Jantar Mantar has a capacity, and as per the High Court's order, 1,000, Ramlila ground 10,000, Burari more than that. But how are you going to enforce it? That is the million-dollar question. Have you your documentation process? Have you your intelligence in process? I do hope I'm wrong, but my guess is that we have not learnt much from the past mistakes.
All right, Mr. Yashovardhan Azad and Dr. Vikram Singh, many questions. We on this channel have brought you the version of the victims. We've brought you several documents, including the general diary entry, which shows that a certain DCP had ordered for use of these weapons. But at what level will the accountability be fixed? The opposition has been raising questions of the government and demanding action as far as the Home Ministry is concerned. What really will be the truth, and when will the public get to know what has happened as far as this matter is concerned? I'd like to thank both of you gentlemen for joining us this evening on the briefing room. A brief diplomatic pause has shattered as fresh US airstrikes target Iran following a missile attack on American forces in Jordan. With strategic waterways threatened and talks stalled, regional mediators now face a desperate battle to prevent all-out war. Here's a report.
U.S. President Donald Trump had ordered to give diplomacy a chance. Instead of reopening negotiations, both sides have now returned to open military confrontation, raising fresh concerns that the conflict could spiral into a much wider regional war.
We're going to be hitting them very hard because it's our turn to hit them. They know it's coming. They're asking us not to do it, but you know, they tried shooting it last night. So we had 5 rockets shot going 8,500 miles an hour, and all 5 rockets were knocked down to the ground. But they nevertheless took a shot, so it's our turn. And we'll see if we get there with an agreement at some point, but we're going to hit them very hard.
The latest American operation followed Iran's surprise offensive a day earlier. Tehran's Islamic Revolutionary Guard Corps said it had targeted a U.S. military base and command center in Jordan in response to what it described as American aggression. Iranian forces also claimed to have struck 3 commercial oil tankers passing through the Strait of Hormuz, after accusing them of using an unsafe and illegal route. Jordan, however, said its military intercepted 5 Iranian missiles before they reached their targets, with no casualties reported. Washington viewed the attack as a major escalation and quickly responded with military force. The events of the past 2 days have dramatically altered the diplomatic landscape. Trump had paused bombing operations in the hope that negotiations could resume, but Iran's missile attack prompted Washington to return to military action. With fresh U.S. strikes, indirect talks have effectively stalled, and both sides now appear locked in another cycle of retaliation. For mediators, the challenge is no longer simply restarting dialogue. It is